Now let us see about the registration of real estate project. Now let us understand first the concept real estate project, especially when the development by the promoter is of a layout plot. Layout plot, that is bigger plot. Suppose a promoter developer has a plot of land of 100 acres and he want to develop that plot in 10 phases of 10 acres each. Earlier that entire project, entire development of 100 acres, it was considered as one project. But now as per Rera, each and every phase that may consist one building, two buildings, three buildings, four buildings, five buildings, might be 10 buildings. But if that is one phase, the entire one phase, that is called as a project, real estate project, not the entire development of entire layout plot of land. So if the promoter wants to develop in a phase of 5 acres each, then the development of that 5 acres means whatever buildings that promoter is going to construct in that area of 5 acres land, then that one phase, that will be treated as one independent project, separate project. And for every such project, the promoter will have to get his each and every project registered with the real estate regulatory authority. Means here the registration of real estate project is mandatory, and for the purpose of registration, that each phase, irrespective of number of buildings the developer is going to develop in that phase, that each phase will be considered as independent project irrespective of the layout plot, the area of layout plot. Okay. Now about registration of a real estate project, there are provisions under section 3 of the Rera. What section 3 provides for? Section 3 provides for prior registration of real estate project with the real estate regulatory authority. Now this real estate regulatory authority, they are established by each and every state and union territories. If there is separate authority for union territory. Okay. In that particular, in Maharashtra, every promoter who comes under this Rera, he will have to register his project with the real estate regulatory authority. Now, what are the provisions pertaining to registration of real estate project with real estate regulatory authority? Number 1, that is, in any planning area, without registration of the project, the promoter cannot advertise, market, book, sell, offer for sale, invite persons to purchase in any manner any plot, apartment, building in any project or part of it. Means unless the project is registered with the real estate regulatory authority, the promoter cannot advertise, market, book, sell, offer for sale or invite persons to purchase a plot, apartment, buildings in that project or any part thereof. Okay. Now means the registration is mandatory. Prior registration, that is mandatory before launching the project, before advertising the project, before marketing the project. Okay. Now at initial stage, when this Rera was implemented on 1st May 2017 in Maharashtra, some relaxation was given to ongoing projects. That ongoing projects registration in 3 months from the commencement of the act was made, this provision was made there. See why this 3 months time period was given to ongoing projects? because certain projects they were nearing completion, and if those projects, if the promoters of those projects, if they can secure OC, that is occupation certificate, within 3 months, then this project they need not be considered under RERA. That is why this 3 months time period was given. But if within 3 months, if that promoter fails to obtain the occupation certificate from the concerned competent authority or local authority, then it was also mandatory for ongoing projects also. Within 3 months, the project has to be registered with the real estate regulatory authority. And for new projects, from new projects starting on or after 1st May 2017, the registration was made mandatory, binding. Prior registration, without registration, means the promoter, he is not allowed to advertise, market, book, sale, offer for sale, or invite persons to purchase plot, apartment, building, flat, etc. in that project. The authority can direct for registration of projects beyond planning areas. Now this means in planning areas prior registration is mandatory, but if beyond planning areas, if expected development that is in bigger volume, then in that case the authority can direct for registration of projects beyond planning area as well. Means this option is with the registering authority, but prior registration of project is mandatory. Now there are certain exceptions to this mandatory provision of prior registration of the project. So here means in that case we can say there is no registration required. Where number one, plot area does not exceed 500 square meters or not more than 8 flats in all phases. Means the entire the plot area, total plot area including all phases, it is not more than 500 square meters, and the total number of flats in all phases, if they are going to be 8 or less than 8, not more than 8, in that case for that project registration is not mandatory. However, this provision of 500 square meters or 8 apartment or flats, it can be reduced if required by the government. If government thinks necessary, this provision also can be reduced, and when the government prefers to reduce this relaxation, then for those projects also the registration will be mandatory, compulsory. Now second ground for exception, that is completion certificate is received prior to commencement of the act. Means for the projects where completion certificate is in hand of the promoter prior to commencement of this act, in that for that project also registration is not required. Third instance, that is where there is a renovation, a repair, a redevelopment, where no marketing, advertising, selling or new allotment of any apartment, plot or building. In that case also registration with regulatory real estate regulatory authority is not required. Means renovation, repair or redevelopment, especially in case of redevelopment we come across mostly, if the all the units, all the flats, all the apartments to be constructed in the redevelopment, if they are going to be allotted to the existing members or existing flat owners only, apartment owners only, and there is no sale, there is no new allotment, in that case there is no compulsion, means the registration under this provision, that is not mandatory. So these are three relaxations where no registration is required. Now the explanation is there. Development in phases. Each phase is a standalone project and needs registration. Just now I have explained. Means what is the project? Means every phase itself is a project, and for every phase there needs separate registration. Okay. Then now this is about registration. Now if we link between registration and in act at further stage, there are provisions for punishment for non-registration of project under section 3. We have seen Under section 3, prior registration of real estate project with real estate regulatory authority. If without registration of the real estate project, if any promoter carries out development activities and starts advertising, marketing, booking, selling, etc., then in that case, what punishment is provided under this act? That punishment is provided under section 59 of the Real Estate Regulatory Rera Act 2016. That is section, what section 59 says, section 59(1), it says that if registration, if there is a violation of section 3, then penalty up to 10% of estimated cost of the project as determined by the authority. Means the promoter will be liable for penalty if order is given by the Rera authority. The promoter will be liable to pay penalty up to 10% of estimated cost of the project. This estimated cost of the project, that is to be determined by the Rera authority, Real Estate Regulatory Authority. Section 59(2) says, failing to comply with orders, decisions, directions issued under section 59(1), that is the 10% penalty. If there is a order, there is a decision, direction of the Rera authority for penalty, and if that promoter fails to comply with that order, decision or direction, or continues to violate the provisions of section 3, that is without registration he continues his project, then punishment, means for second instance there is a punishment, means if that there is a violation, there is failing to comply and continuation of the same default, same violation, in that case there is punishment with imprisonment up to 3 years or with fine to a further 10% of project cost or both. Means first time there is penalty of up to 10% of the estimated cost. Failing to comply with this order of penalty, then further penalty is increased up to more 10%. Besides penalty, there is imprisonment, punishment of imprisonment up to 3 years to the promoter. So these are the punishments under the act for violation of the provisions of section 3 of the Rera. Now section 4 of the Rera, Real Estate Regulation Act, that is section 4, application for registration of a real estate project. Okay, means as per Rera, 1 year was given to submit the application manually in form A, and thereafter, means within 1 year the states were directed to establish web-based technology, etc. But in Maharashtra, from the day 1 only, that is from 1st May 2017, we have web-based technology to register the projects, to file complaints, etc. I mean full-fledged, fully operational web-based system was developed by the government of Maharashtra prior to commencement of this act in Maharashtra. Okay, means now for registration of real estate project, application is submitted online on the website of the Real Estate Regulatory Authority. So application in the prescribed form and manner along with fees by the promoter to the authority, means application along with the required fees that is required to be submitted to the authority. Documents, which documents are to be submitted along with the application for registration? 1. Details of enterprise, means the enterprise promoter, partnership firm, company, or by whatever nature of that enterprise is. Details of that enterprise, that is name, registered address, type, that is partnership or society or proprietorship, company, competent authority, as the case may be. Registration details, means registration of that enterprise, registration details, names and photographs of promoters, Means if one promoter is there, the name and photograph. If more promoters are there, in names and photographs of all promoters, they are required to be uploaded along with the application. Next, details of his projects of past 5 years completed or being developed, the current status, any delay, details of cases pending, details of type of land and payments pending, means pertaining to all these things. Details of past 5 years, they are also required to be submitted to Rera authority along with application. Then approvals and commencement certificates from the competent authority. Where the project is developed in phases, copy of approvals and commencement certificate for each of such phases. Then sanctioned plan, layout plan and specifications of proposed project phase and the whole project. Further, plan of development works and proposed facilities including facilities for firefighting, drinking water, emergency evacuation services, use of renewable energy, etc. Then location details with clear demarcation of land dedicated for the project along with its boundaries including the latitude and longitude of the end points, pro forma of allotment letter, agreement for sale, conveyance deed, a number, type, carpet area of apartments along with the area of the exclusive balcony or veranda and the exclusive open terrace areas appurtenant with the apartment, number and area of garage for sale in the project, names and addresses of his real estate agents if any for the proposed project, names and addresses of the contractors, architect, structural engineer and other persons, then a declaration supported by an affidavit signed by the promoter or authorized person, then such other information and documents as may be prescribed. Means along with the application, all these documents pertaining to all the details, all these details, they are also required to be submitted to the real estate regulatory authority for the purpose of registration of the real estate project. This is as per section 4 of the Rera. Now certain additional requirements are there which are also required to be complied with, means the information that is also required to be submitted to the authority, and those provisions they are made by the Maharashtra government under Rule 3. So what we have seen under section 4, that is in the act passed by the central government. Then rules are framed by the Maharashtra government in the rules under Rule 3. Additional some documents are prescribed. Those documents are also required to be submitted to the Rera authority along with the application for registration of the project. So which are those documents? Have a look. Number 1, information and documents as per the act that we have seen right now. Then additional information and documents, which are they? Authenticated copy of the PAN card of the promoter or promoters. Then if promoter is individual, personal details and photograph of promoter or his authorized representative. Then if the promoter is an entity, then personal details and photograph of chairman, partners, directors, etc. Then title report is also required reflecting the flow of title with authentication of such title by practicing advocate. Then where the promoter is not the owner of the land, in that case a copy of a collaboration, development, joint development agreement, etc. between the promoter and landowner and title report thereto. Then the information relating to the encumbrances and details of proceeding of sub judice cases. Then sanction plan, FSI, TDR, other entitlements as per the DC rules, that is development control rules and regulations. Then amenities and common facilities. Further proposed plan, proposed layout plan of the whole project and FSI proposed to be consumed. Then proposed FSI to be consumed and sanctioned FSI. then proposed number of building or buildings, wing or wings, and sanctioned number of buildings or wings, then proposed number of floors in building wing to be constructed and actually sanctioned, aggregate area in square meters of the recreation open space, then the number of covered parking spaces, then particulars of architecture and design standards, types of construction technology, earthquake resistance measures, and the like to be adopted for building common areas and amenities, facilities, etc. Nature of the organization of the allottees to be constituted and to which title of the land parcels is to be conveyed on completion of the real estate project, and other information and documents as may be required by the authority under the rules and regulations. So these additional documents, they are also required to be submitted as per rule 3 of the Rera rules, which are framed by the government of Maharashtra. Now, along with the application for registration and the documents, those we have seen now, the promoter will have to pay the fees for the registration of a real estate project. So, what is the fees? That is mentioned under Rule 5. Okay. At the time of application for registration fees calculated on the area of the land proposed to be developed at the rate of rupees 10 per square meter, subject to a minimum of rupees 10,000 only and a maximum of rupees 10 lakhs. See, these are the latest amendments. Earlier, this amount was a minimum of rupees 50,000 only. Okay, minimum amount, that is reduced to 10,000. See, rupees 10 per square meter, minimum amount, that is rupees 10 per square meter, subject to a minimum of rupees 10,000 only, and then maximum rupees 10 lakhs. Okay, this is the fees for registration of a real estate project, that is calculated on the area basis, the area on square meter basis, but subject to minimum 10,000 and maximum rupees 10 lakhs. And in case of plotted development, where means land is there, land is divided into different plots and plots are sold to the allottees in that case. And in case of plotted development, the promoter shall pay registration fee calculated on the area of the land proposed to be developed at the rate of rupees 5 per square meter. Here the rupees 5 per square meter, maximum limit is not given, but that is at least rupees 5 per square meter, it is fixed. That rupees 5 per meter, that is required to be paid to the Rera authority as fees for registration of the real estate project in case of a plotted development. Okay, the fees for registration of real estate project, that can be paid through NEFT or RTGS system or any other digital transaction mode. Means here cash payment, that is not allowed. Okay, this was about the registration form, documents to be submitted and fees for registration of the real estate project. Now, if the promoter has submitted the application, he and all documents, and he has paid fees also, but at some later stage, if he wants to withdraw the application for registration, then in that case, what are the provisions? They are mentioned under Rule 7, of the rules framed by the Maharashtra government on 21st April 2017. The promoter can withdraw the application for registration before the expiry of 30 days of its submission to the authority. Means if he wants to withdraw the application for registration, then he will have to withdraw the application before the expiry of 30 days of its submission to the Rera authority, Real Estate Regulatory Authority. And what about refund of fees paid by the promoter? Means the fees is refunded but after retaining amount for administrative charges towards processing of application. This amount that is to be decided by the authority. That discretion is with the authority. Means after retaining amount of administrative charges towards processing of application, the remaining amount is refunded to the promoter within a period as may be specified in the regulation. Means as specified in the regulation, this amount is refunded by the Rera authority to the promoter. Now, besides this, there are some disclosures which are required to be made by the promoter while submitting the application for registration. Okay, which are those disclosures by the promoter? As per Rule 3, Sub-Rule 8, the promoter shall disclose land cost in the real estate project, cost of construction in real estate project, and estimated cost of the real estate project. These three costs, means cost of land, cost of construction, and estimated total cost of the real estate project, you will have to disclose while submitting the application for registration of the project. Further, as per Rule 4, the promoter means there are provision for disclosure by promoter of ongoing real estate projects. Is ongoing real estate projects. About ongoing real estate projects, which disclosures the promoter is required to make while submitting the application. That is, if OC BCC means occupation certificate or building completion certificate is not received, application for registration of project within 3 months. Means if the project is ongoing project and within 3 months if occupation certificate or building completion certificate is not received, then that project has to be registered, and the promoter will have to apply for registration. Yes, that was at initial stage only. Now, disclosure of all details of ongoing projects as per the act that we have seen. Then the extent of development of the project and common areas etc. till the date of application. Means development कुठेपर्यंत झाली ongoing project ची application तारखेपर्यंत. Then the original time period disclosed to the allottees for completion of the project. The promoter shall also submit a certificate from architect certifying the percentage of completion of construction work, a certificate from engineer for the estimated balance cost to complete the construction work, a certificate from chartered accountant for the estimated balance cost to complete the project, a certificate from chartered accountant certifying balance amount of receivables from the allottees and estimated amount of receivables in respect of unsold apartments. Okay. Then further disclose the number of the apartments sold, size of the apartment based on carpet area. Then disclose the area of the plots sold in this plotted development. Disclose the area of the plots sold including extent of share of common areas and amenities etc. Then construction of project in accordance with sanctioned plan, layout plans and specifications. So these are the disclosures. These are the additional requirements in the form of disclosures that is to be made by the promoter while applying for registration of the new project. Okay. Now we have seen that the promoter is required to submit one declaration along with the application for registration. So what are the contents of that declaration supported by an affidavit? Okay, that declaration that is in section 4 subsection 2 clause L. Okay, that he has, means the contents of the declaration, that he has a legal title to the land along with legally valid documents authenticating title if such land is owned by another person, that the land is free from all encumbrances, details of the encumbrances, rights, title, interest or name of any party or over such land along with the details, then the time period within which he undertakes to complete the project or phase, then that 70% of the amounts realized from the allottees from time to time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of construction and the land cost and shall be used only for that purpose. Further, the promoter can withdraw amounts in proportion to percentage of completion of the project. The amounts can be withdrawn after it is certified by the engineer, architect, chartered accountant that the withdrawal is in proportion to the percentage of completion of the project. See, audit of accounts within 6 months after end of every financial year by a chartered accountant who should verify that the amounts have been utilized for that project only and withdrawals are in compliance with the proportion to the percentage of completion of the project. This much restriction are there, and everything is mentioned in that declaration. Then that he shall take all the pending approvals on time from the competent authorities, then that he has furnished such other documents as prescribed by the rules regulations under the act. So these are the contents of the declaration that is to be given by the promoter for registration of the real estate project. And penalty for contravention of this section 4, that is penalty for providing false information or contravention of the provisions of section 4, penalty up to 5% of the project cost. If he gives any false information, that penalty up to 5% of the project cost can be levied to the promoter. So this was about the contents of the Now, after submission of application for registration along with the required documents as per the Act, the rules, submission of undertaking in the form of affidavit, declaration in the form of affidavit, payment of registration fees, etc. There is provision under section 5 about a grant of registration. Section 5 provides for grant of registration to the real estate project. See, on receipt of the application, the authority shall within a period of 30 days grant registration, provide a registration number including a login ID and password to the applicant for accessing the website of the authority and to create his web page and to fill therein the details of the proposed project. Means on receipt of the application along with the fees and all other required documents, the Rera authority, that is real estate regulatory authority, will have to grant registration to that project within 30 days on receipt of the application. And along with the registration, granting registration, along with giving a certificate of registration of the project, the Rera authority will provide registration number and provide login ID and password to the applicant so that the applicant will access the website of the Rera authority, because every promoter is required to create a web page, separate web page for his every project, and to fill therein the details of the proposed project. This web page is also required to be updated quarterly. After every 3 months, the web page is required to be updated, and this web page is open for public viewing purpose. So for that purpose, he is given login ID and password to access the website of the Rera authority. If the registration is not given, then within 30 days only, the Rera authority will have to reject the application for reasons to be recorded in writing. Means within 30 days only, either to grant registration or reject the application for registration. But while rejecting the application for registration, the authority will have to record the reasons for rejecting the application in writing, and that letter, rejection letter, that will have to be issued to the promoter mentioning the reasons for rejection of the application. Rejection of application after giving opportunity of being heard to the applicant means before issuing rejection, before giving rejection letter of rejection of application, that promoter is given due opportunity of being heard. Then Further, if the Rera authority is firm that the registration cannot be given, then it gives a letter for rejection of the application. Now there is provision under subsection 2 of section 5 about deemed registration. What is that? If the authority fails to grant or reject the application for registration within 30 days, then the project shall be deemed to have been registered, and the authority shall within next 7 days provide a registration number, login ID and password to the promoter. Means after expiry of 30 days, within 30 days, if there is no action from the Rera authority, then the project is deemed to have been registered, and within next 7 days the Rera authority will have to issue the promoter a registration number, login ID and password to access the website of the Rera authority. Further, the registration shall be valid for a period declared by the promoter for completion of the project or phase thereof. Means here, while applying for registration only, the promoter will have to mention the period required by him for completion of the project, but that unnecessary long period, that will not be considered. Nowadays mostly all these promoters, they prefer 5 years period, but unnecessary long period, that will not be considered. But this option is given to the promoter while submitting the application for registration to mention the period during which that registration shall be valid. Okay. Then about grant or rejection of registration of the project, besides provisions in the Act, there are provisions in the rules as well. Rule 6 is about grant or rejection of registration of the project. See, let us see what is the provision in rules under Rule 6, that is about grant of registration of the project. That when the project is registered, then issuing registration certificate with a project registration number. Means here the authority will have to issue registration certificate with the project registration number. Stay or injunction period is excluded from the period of validity of registration. See, the period of validity of registration, that is mentioned, but in between, if there is a stay or injunction to the project, and because of that the work is stopped at site, then that period of stay or injunction given by the court, that is excluded from the period of validity of the registration. Okay. Then further, if registration is not granted, then rejection of registration of the project and issuing a letter to that effect to the promoter and competent statutory authorities as well. Means the letter of rejection that is issued to the concerned applicant promoter, as well as copy of the same that is issued to the competent or statutory authority for their information, like local authorities, municipal authorities. Okay, rejection after giving adequate opportunity of being heard, that is in Act is also, that provision is there, in rule also that provision is there. Now there is a provision for extension of registration, because while applying for registration, the promoter will have to mention the period for which his registration shall be valid, and during that period that promoter will have to finish his project, he will have to obtain occupation certificate or building completion certificate. But under certain circumstances, the extension can be given, extension to the registration can be given by the authority. That provision is under section 6 of the Act. Okay, extension by the authority on the grounds of force majeure, that is beyond control of the promoter. If the reasons, grounds for delay to complete the project, that is beyond control of the promoter, that is called as grounds of force majeure. In that case, on an application made by the promoter and on payment of fees prescribed, here the promoter will have to apply for extension and he will have to pay the additional fees for extension. Then extension can be given if the grounds are genuine. If the grounds are of force majeure in nature, then the extension can be given by the authority. but in aggregate the extension shall not exceed a period of 1 year. Means total extension to be given under all grounds that shall not exceed a period of 1 year. If the grounds they are means the authority is not satisfied with the grounds, then that application can be rejected. Rejection of application for extension of registration after giving an opportunity of being heard to the promoter. Now there is explanation about force majeure, which grounds are covered under force majeure situation. That is case of war, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature affecting the regular development of the real estate project. They are considered as grounds for force majeure. So this was about extension of registration under as per the provisions of the Act. There are provisions for extension in rules as well. Under Rule 7, there are provisions for extension of registration of the real estate project. Here the application is to be made by the promoter in prescribed form. Explanatory note setting out the grounds and reasons for delay, that is also to be submitted along with the application. Documents supporting such grounds and reasons, documentary evidences, they are required to be submitted along with the application. On force majeure grounds, the authority may at its discretion waive the fee for extension. Here the authority has a discretionary power to waive the fees for extension. Okay, then the authority can give extension, that is grant of extension by way of a letter in prescribed form. Copy is given to the promoter and if rejected, then that rejection letter is given in prescribed form after giving to the applicant an opportunity of being heard, that is there, and intimation is given to the respective competent authority and statutory authorities as well. Whenever there is a rejection, the intimation is given. Means intimation means that letter is issued to the promoter and intimation is given to the competent authority or statutory authorities for their information. Now, what is the fees for extension? Now, as per under Rule 7 only, sub Rule 3 is there, that fees is given, fees for extension at the rate of rupees 10 per square meter, subject to a minimum of rupees 10,000 only and a maximum of rupees 10 lakhs only. See, the fees that is to be paid at what rate at the time of registration of the project, the same rate, at the same rate and the same amount that is required to be paid by the promoter for extension of the project. Means the extension of project itself is a new registration, because full fees, that is rupees 10,000, that means rupees 10 per square meter, subject to minimum of rupees 10,000 only and maximum of rupees 10 lakhs only. This is fee that is also required for submission of application for registration. Means the same fees is also applicable while applying for extension. That is why the promoter should take due care, means utmost care, to complete the project within the time period as agreed upon, within the period during which the registration is valid. Because again, if the project is going to be delayed, then again you will have to apply for extension and you will have to pay the full fees as it is required in case of new registration. Okay, and in case of plotted development at the rate of rupees 5 per square meter, means the same fees which is required to be paid at the time of applying for fresh registration for real estate project, the same fees that is also required to be paid while applying for extension to the validity of the project. Okay, now about revocation of registration. provisions are given under section 7 about revocation of registration. The authority has power to revoke the registration granted given to the promoter. Okay? See, what are the provisions under section 7 about revocation of registration? The registration can be revoked by the authority on complaint, means on complaint made by the competent authority, statutory authority, allot is association, allot is legal body, or any other association or body working as a association of consumers also. Means if there is a complaint against the promoter about the project, etc., or suo motu, or on recommendation of competent authority. See, on complaint or suo motu or on recommendation of competent authority, and after being satisfied that, what promoter makes default in doing anything required under the act, rules and regulations. Means if promoter has made any default, then promoter violates any of the terms, conditions of approval given by the competent authority. Means approvals, that is construction approvals, competent authority, that is municipal corporation, etc. If there are certain terms and conditions while giving the approvals, that is commencement certificate, etc. And if there is a violation by the promoter in the terms and conditions of the approvals given by the competent authority, then promoter is involved in any kind of unfair practice or irregularities. See, the unfair practices means list of unfair practice that is also given in the act itself. Then the promoter includes in any fraudulent practices. See, on those grounds, the registration of the promoter can be revoked, registration of that project. Means during this case, when complaint is received or recommendations or on suo motu, etc., then for giving opportunity of being heard, notice is given to the promoter stating grounds, and after considering causes shown by promoter within 30 days of notice. This notice is issued to the promoter within 30 days. The promoter will have to show causes why his registration of that project should not be revoked, and after giving all these opportunities and after being satisfied, the registration can be revoked. But the authority has discretionary power, instead of revoking registration, permit to remain in force that project subject to further additional terms and conditions. If the authority feels that at this point of time there is not need of revocation of registration, then authority can impose some additional terms and conditions and permits to that promoter to continue his project, to remain in that project. Okay. If the registration anyhow is revoked by the authority, then after revoking of registration, what further? After revoking of registration, the authority debars the promoter from accessing website and specify his name in the list of defaulters and display his photograph on its website, and Rera authority in other states and union territories about the revocation. See, means there is a revocation of registration, then that promoter is debarred from accessing website of the authority. His name or more persons are there, means their names are specified in the list of defaulters and they are displayed on the website of the Rera authority, and his photograph or photographs, their photographs are also displayed on the website of that Rera authority, concerned Rera authority, as well as Rera authorities of other states and union territories. This entire information that is displayed all over the India with Rera authorities of other states as well and union territories as well. Then this is first step after revocation of registration. Now project is stopped after revocation of registration. Then what to do with the remaining work of development? Then for that, to facilitate remaining development works to be carried out in accordance with section 8. We are going to see the section 8, what are the provisions in section 8, in what manner in case of revocation of registration, or if the promoter has failed to complete the project, then in what manner the remaining work of development that is to be carried out, that is given under section 8, that we are going to see. Further, the authority directs the bank holding the project bank account, because the developer will have to open a separate bank account for each project, and after revocation of registration, the Rera authority directs the concerned bank holding the project bank account to freeze that account, and thereafter take such further, means initially the authority will direct the bank to freeze the account and not allow to the promoter to withdraw any amount, to operate the account and to withdraw any amount from the bank account, and further take such further necessary actions and defreezing of the said account towards facilitating the remaining development works in accordance with the provisions of section 8. Because if remaining development work is started in accordance with section 8, then that account, bank account, that again it is defreezed for withdrawal of the amount to carry out the remaining development work. Okay. Then further what, after revocation of registration, to in order to protect the interest of the allottees or in the public interest, issue such directions as it may deem necessary. Means in order to protect the interest of the allottees, means the persons who have purchased the flats, apartments in that project, or in public interest. If any further directions they are required to be issued, the authority issues those further directions as well. So this was about revocation of registration as per section 7 of the Rera Act. Now regarding the revocation, there are provisions in rules also. Under Rule 8, there are provisions after revocation of registration of the project, upon revocation of registration, to inform the promoter and the concerned competent authority, that is municipal corporation or any other statutory authority. Then prior notice to the promoter of not less than 30 days, means that 30 days notice to show causes that is given to the promoter, stating the grounds and considering any cause shown by the promoter within the said period. Notice to the concerned competent authority which has granted approval to the real estate project and association of allottees if formed at that stage, and if not formed, notice to the allottees individually to submit their say in that behalf. Means in the process of revocation of registration, besides the opportunity of being given to the concerned promoter, means opportunities are given to competent authority, to the allottees as well, to submit their say in that behalf. If there is association of allottees, then through association of allottees, the say can be submitted before the Rera authority. And remaining development works as per section 8 they are carried out, and measures to protect the interests of financer, etc. Means here the when the registration is revoked, interest of the allottees, interest of the financer, that is not affected adversely. Rera authority takes due care of the interest of the allottees as well as financiers by carrying out the remaining project as per the provision of section 8. Then opportunity of being heard is given to any party which through instrument of debt or equity have created third party interest in the real estate projects. If any other persons they have third party interest in that real estate projects, they are also given opportunity of being heard by the Rera authority. Means these additional precautions they are also taken under Rule 8 by the Maharashtra government while framing the rules. Now what after lapse of registration or revocation of registration? that is in what manner the remaining work of development that is to be carried out, that we have seen that under section 8 those provisions are there. So what are those provisions under section 8? That is obligation of authority consequent upon lapse of or on revocation of registration. Means either if within the time period given, if that promoter fails to complete his project and fails to give the possession to the allottees, or in case of revocation of registration. What further? Means in what manner the remaining development work that is to be carried out, that is given under section 8. See, let us see those provisions. Upon lapse of the registration or on revocation of the registration, the authority may consult the appropriate government to take such actions as it may deem fit. Means the authority will consult with the appropriate state government, means with the state government, means about the future actions to be taken. Then including the carrying out the remaining development works by competent authority, because state governments, they have competent authorities engaged in this field, like MHADA is there, SIDCO, MMRDA, these authorities are there, they carry out construction activities. Then by consulting with the government, state government, means opportunity that efforts are done to complete the remaining development work through these authorities, development authorities, or by the association of allottees. Means or to complete the remaining work, association of allottees is formed by that time. Means the allottees who have purchased the flats, their association is formed, and through that association the remaining work can be carried out, because funds are there in the bank account, that is earmarked bank account is there, that is freezed. Now it can be defreezed, and the association is given authority permission to carry out the remaining work, because all permissions are there, development required development permissions, everything is there, payment is also there initially to be used. Then that means there are two options, means to carry out the remaining development work, there are two options before the authority by consulting with the government, either to complete the remaining development works by competent authority, or by the association of allottees, or in any other manner as may be determined by the authority. But these two options are available. Okay. Direction, decision or order of the authority under this section shall take effect after the expiry of the period of appeal. Now, means there is an opportunity to the promoter to challenge the order of the authority of revocation of registration in appeal to the tribunal. Appellate tribunal is there, that appeal, and after expiry of the period of appeal only, this section provisions of section 8, they can be evoked. Opportunities or options can be taken under section 8 after expiry of the period of appeal only. In case of revocation of registration of a project, the association of allottees shall have the first right of refusal for carrying out the remaining development works. Means the authority has options either to carry out the remaining work by competent authority or by the association of allottees, in that case, or by any other manner. In that case, the authority will have to consult, we have to ask first the association of allottees, and if they show their unwillingness, if they refuse to carry out the remaining development work, then only the authority can go for other options to carry out the remaining development work. Means first opportunity, first option that is given to the association of allottees to carry out the remaining development works. This is as per section 8, to carry out the remaining development work after revocation of registration or after lapse of registration. Okay.